Hello, my name is Frank Fee and I'm a barrister at 1KBW.
Hello, I'm Caroline Harris. I'm a barrister at 1KBW also.
We're going to be talking today about vulnerable witnesses and the way in which the rules on vulnerable witnesses, particularly in family cases, have become more explicit in the last couple of years, and drawing on the experience of criminal practitioners, and Caroline is a criminal practitioner, as to how vulnerable witnesses have been treated in criminal cases for now some years. There are, of course, differences between the two. The family cases are much more malleable in terms of the rules and the application of the rules. Criminal, much more strict in the way their rules are applied, but there are aspects in which both sides can learn from each other. We're going to see what we can discuss about that this morning.
Starting with the changes recently in the family rules, Frank, we've now got slightly more of a structured system, haven't we, in the family rules than we did previously? We
have. In the last 12 months or so, Part 3A of the Family Procedure Rules has come into play, and the Practice Direction 3AA in those rules, which gives guidance as to how those rules should be applied. I have to say, I've had recent experience, though, of judges and senior practitioners still not really understanding the rules, still struggling with the mandatory aspect of those rules, and still not fully realising that these are rules which must be applied in every case.
I've had the same experience, cases where judges aren't actually even considering the fact that witnesses now have to be considered. Vulnerability has to be considered, not only by the parties but also by the court. So I've had a couple of cases where judges have criticised the parties for not raising it, when in fact the obligation is also there on the judge to be alive to it also.
Well, the case in which I've just been dealing over the weekend, in fact, is a very, very busy judge in a massively busy care centre up north, trying to deal with a case in which there's been an allegation of sexual abuse by two girls against their father, and trying to keep a case on track by coming up with what you might call, without disrespect, makeshift means of getting the case up and running and dealing with the rights of both the father and the children as witnesses, and yet coming up against what is clearly from the rules a set of procedures which she must comply with, but which haven't been complied with so far. The case is meant to start today. So it's easy to see how people are not really grasping the necessary aspects of these rules and still making mistakes which could lead to real problems in the future.
Do you think it's because we don't have a proper statutory background? Rather than we've got the rules and the practice direction, but at the moment there's still a huge call to have a statutory formal system that assists with regards to family procedures.
I think you might be right. I think if they had put these rules in as a series of amendments to the Children Act, rather than as a series of amendments to the rules, we may well have a better grasp of what is necessary. That may be right, but there they are the rules and they are there to be complied with.
And that's where crime is slightly, well, very much in advance of the family system, because we do have the statutory structure, which has been in place for many years. However, in the criminal system, although we put a great system in place, very often due to the lack of funding, we actually find that those that are most vulnerable actually aren't being given now as much assistance as they were in the past.
What are the trigger points in crime? When do you decide that someone's going to be treated as a vulnerable witness or as a vulnerable defendant?
Well, the police have a duty to be alive to that from the very beginning, even in the investigation stage. But at the PTPH, so the first hearing in the criminal courts and the Crown courts, we have a form which we go through which actually requires that we're identifying at that stage who is vulnerable, both witnesses and defendants. Is also part of the criminal procedure rules, Rule 3, where we actually have to be alive to that fact.
I'm actually normally against checklists, but I have to say that given the recent experience I've had over the weekend, it might be worth us having a checklist in family proceedings, so that at the first hearing it is very clear that people have considered the possibility of the need to use the vulnerable witness regulations. I think that would be really helpful, actually.
The form is very good. The PTPH form sets out very clearly what we have to consider. And I think actually the case management hearing, that would be something which would be very helpful for everybody, to be going through, ticking off what they need to think about. And actually also then, when you go to a later hearing, you can identify what's been missed and why, which often highlights that it's a new thing that's come about. So, for example, someone is now more vulnerable. As we all know, often during proceedings, due to the stress of them, someone who was on the edge of being very vulnerable and needing assistance, by the time you get to the next hearing, because of the pressures, and family possibly because they've been being assessed whether or not they can care for their child or not, they may now actually need an intermediary, whereas at the first hearing they may not. So actually also the process of seeing what has changed by having the starting point and working on can be helpful.
I think it's right also, isn't it, that isn't there an official list of intermediaries in criminal cases?
There is, but there's a difference between witnesses, so intermediaries that the defendants use and intermediaries that are used for Crown witnesses.
And what is the difference?
So you have registered intermediaries, which is the list you're talking about, which are for Crown witnesses, prosecution witnesses. Defendants, however, can't have registered intermediaries. They have non-registered intermediaries, which is a slightly biased system. They're usually very, very good, and they're obviously professionally regulated, but we don't use the same set of intermediaries, which is bizarre.
So unusually you have prosecution intermediaries and defence intermediaries.
Indeed.
I see. I don't see how that works.
Well, there's different rules. So there was always a different set of, I know, it's very strange. So it's always a completely different set of rules for defendants. So defendants were not entitled to the same special measures that all the other witnesses in criminal proceedings were. They were explicitly excluded when they first came about, the rules. We are now moving slightly further forward. There was a case, the Sevenoaks case, which has been in play for 10 years, which actually highlighted that, in fact, defendants were obviously also very important to criminal proceedings, and actually in order to ensure a fair trial, they should be entitled to special measures too. So we circumvented the statutory law there. Now there are statutes statute which actually is unhelpful for defendants. So the new statutory provisions, potentially, if they came into force, would prevent defendants probably having intermediaries for the course of the entire trial, rather than at the moment there being those in the interest of justice provisions which have circumvented the statute, which is awful. Lady Justice Hallett is one of those behind supporting there being more, the equivalents for both Crown witnesses and defendants. But at the moment there is a real risk that will go.
And in family cases, they're just treated as if they're a pool of experts, in the same way that expert witnesses are treated. So everybody gets access to the same pool, a pretty small pool anyway. So at least perhaps we've made some advances in family work that the criminal people need to catch up with for a change.
No, well, REW is something that family do far better than crime. So, as you know, REW, the assessment of a child before they give evidence, if they are going to give evidence. Yes. We don't have anything that's equivalent to that.
So there's nothing in crime to check whether a child is even capable of giving useful evidence?
No, I mean, we have obviously police liaison, they will assist, we have the defence lawyers who would instruct a psychologist, but we don't have the court system saying that there must be an assessment of a child before they are even asked to give evidence, which actually is quite short-sighted.
Yeah.